Well, good afternoon, everyone. My name is Bill Williams, and I'm the United States Attorney for the District of Oregon. After approximately 21 hours over 3 days, a federal jury here in Portland has returned its verdicts against Jason Patrick, Dwayne Emer, Daryl Thorne, and Jake Ryan, all of whom were active participants in the 41-day armed occupation of the Malheur National Wildlife Refuge that took place in Burns, Oregon, beginning in January of last year. As you may know, Jason Patrick was found guilty of conspiracy to impede officers of the United States. Daryl Thorne was found guilty of conspiracy to impede officers of the United States and possession of firearms and dangerous weapons in federal facilities. Dwayne Emer and Jake Ryan were both found guilty of depredation of government property that pertains to the trenches at the Wildlife Refuge. The sentencing is scheduled for Wednesday, May 10, 2017 here in Portland. Freedom of speech and expression are core values and rights that I and others have sworn to protect and uphold. In this case, the defendants were not on trial for their beliefs, but rather for their conduct. Taking up arms and occupying federal lands and property that interferes with federal employees discharging their duties is and will continue to be illegal. We cannot have people taking over government offices and facilities at the end of a gun and expect no consequence. The jury has spoken, their verdicts speak to their view of the evidence, and I respect the American judicial process and remain convinced it's the best in the world. For 41 days last year, these individuals prevented U.S. Fish and Wildlife Service and BLM employees from doing their jobs as stewards of the land belonging to all Americans. They purposely interfered with the daily lives of residents of Burns, Hines, Harney County, and members of the Burns Paiute tribe. The negative impacts of those actions continue to this day. Our communities and state are stronger because of our joint effort to bring these individuals to justice. The rule of law matters. Taking up arms because you do not like how things are done can never be accepted as a lawful way to protest. The good people in rural Oregon who are ranchers, loggers, farmers, and small business owners understand the difference between disagreeing with land management policies and working together to bring about change versus outsiders with a political agenda taking over property with guns and claims of being patriotic. A voice for change and one's votes are more effective than threats in an AR-15. I would like to begin by thanking the residents of Burns, Hines, and the Burns Paiute tribe and all members of Harney County, Oregon, and others who were victimized by the actions of these individuals. Your patience with and commitment to both trials was a motivation to everyone involved. I want to thank law enforcement in Oregon, and that includes a special thank you to Harney County Sheriff Dave Ward, the Oregon State Police, the Oregon Sheriff's Association, and the countless local and tribal law enforcement personnel from around the state of Oregon that worked tirelessly to bring about a peaceful resolution to the stand-up. I would like to thank the employees of the United States Fish and Wildlife Service, United States Forest Service, and Bureau of Land Management for their courage and determination to continue serving our country in various capacities despite having their workplaces taken from them and despite having to dedicate countless staff hours in support of these two tribes. I would like to thank the FBI for their outstanding investigative support through every phase of this process. Their professionalism and commitment were essential in bringing about a successful resolution to the trial. And finally, I would like to thank our trial team. Standing with me today is Ethan Knight and Jeff Barrow. Their hard work and commitment to bringing these defendants to justice can't be overstated. The process of prosecuting these individuals required an extraordinary level of effort and unflappable commitment on behalf of staff at all levels in our office. Very proud of them and thank them for their tremendous effort. I would like to introduce two of my colleagues who are here with me today, Mr. Loren Cannon, FBI Special Agent in charge of the FBI's Portland Division, and of course I've introduced Ethan Knight and Jeff Barrow. So I'm available to take any questions you might have.
Can you talk about what went into deciding whether to bring the conspiracy charges against this round of defendants?
Sure. So, the evidence didn't change in terms of who was arrested following the occupation. And so we believe in the wrongfulness of that conduct and that the matter needed to be brought before a jury. And that includes the remaining 4 defendants who have been convicted. Any other question?
What changed in terms of strategy, if it was the same charge for both trials?
Right. So, I would defer to the 2 trial lawyers in the courtroom to answer those questions. Ethan?
Certainly. I think really there are 2 responses to that question. First, we did make some strategic changes based on the way the evidence was presented, the manner in which it was presented, certainly emphasizing how the FBI handled the investigation. But at the end of the day, the facts were essentially the same. And in our system, juries can reach different conclusions. And that's why we are focused on the defendants, the facts, and the law. And we're not influenced by, a lot of the political currents or outside influences that take place when you have a verdict like we had in October. So while there were changes, we sort of stayed focused on the facts, the victims of the Fish and Wildlife Service, and that's why we're here today.
Do you think it's just that the occupation leaders, were acquitted, and yet some of the big players are now facing felony conspiracy convictions?
I don't think that's a question we can really answer. I mean, because I go back to the fact that we operate in a system that relies upon juries evaluating evidence as they see it. And so, again, we're addressing the conduct that we believe was unlawful from the beginning. And the fact that there were 2 different juries who viewed the evidence differently is not uncommon in terms of the way the American jury trial system works.
Why add misdemeanors in this trial and not the first?
Well, I think it's after the first jury, we looked at what we needed to do, if anything, differently for the second round, and thought it was appropriate to bring misdemeanor charges.
Were there other things that you did differently the second round?
Well, I think Ethan's kind of addressed that answer in terms of strategy. Yes,
If
sir.
you could do this over again, would you have tried the minor players first to sort of work out the bugs and then try the leaders of the occupation?
I don't, the selection of the sequence of who was tried first was in consultation with the court and other attorneys. So in terms of strategy, I think it's more a reflection of on the one hand, the custody of some of the individuals in the first trial needing to go to trial first, and those happen to be other leaders in the occupation.
Going through the 2 trials now, you look back, you say, well, we got some convictions here, last time we didn't. Have you thought of, I guess, in your minds, what you think went wrong back in October? Ethan or Jeff?
What went wrong in October?
Well,
Just kidding.
I don't know.
No, I mean,
Well,
absolutely. I mean, I think we took a very hard look, as you do in any case where you have the same facts in 2 trials, and given the outcome and given the verdict the first time, we did our best to listen to the jurors who did speak to us. We did our best to look at what we did, and we did our best to see how we could change the second time around. I think that's absolutely our responsibility and our role in the process to try and make those adjustments to see that justice was done. And if we hadn't done that, I think we would not have been doing our jobs.
Well, in the first case, there seemed to be a lack of focus on the employees who were the ones that were impeded, and we certainly tried.
Up to the podium, sir.
I was just saying, in the first case, there seemed to be lose some focus on the employees that were actually impeded by this, and so in the second case, we tried to emphasize that, and I think that I think the jury got that this time.
How significant was it not having Evan Bundy in the set of defendants and, you know, such a larger-than-life almost presence in that first trial?
I think at some level that's a question for the jury, how that affected the deliberation and the process. Certainly his role as the leader affects the way the evidence is presented and affects the manner in which we discuss the roles of everyone involved. But you know, at the end of the day, I think that's in some ways a question only the jury can answer, both with respect to his presence at the first trial and with respect to the way he testified in this case.
What's the message that the verdict sent in your mind?
Well, I think the message is, again, I touched on this in my opening comments. We can't have folks taking over buildings and property that belong to all of us, all Americans. It's not just the citizens of Harney County. It's all Americans own this federal property. And again, folks can have they have the absolute right to disagree with land management policies. But the fact is, the majority of folks who live in rural America understand the way to resolve those issues is to get involved. Harney County is a wonderful example of how members of a community who have differences of opinions about land management issues work with each other. The High Desert Partnership is a wonderful example of ranchers, environmentalists, county officials, and environmentalists who have differing views of how things should be done, but they sit down and spend years working out an agreement of how they're going to address those issues. The outsiders who came in with Mr. Bundy and his followers were just that. They were outsiders. I presume, were unaware of just how well things work in Harney County in terms of the civic involvement. So folks in rural Oregon understand that if they have a disagreement, there's a democratic process in place for them to raise their concerns and challenge the government through their involvement and their own elected officials. They don't need to do it at the end of a gun. So from our standpoint, folks who have plans to take over federal lands, federal properties by force and intimidation and at the end of a gun will be prosecuted. I hope the message goes out that it's not okay to do this and will continue to be illegal.
Can you discuss the decision to have a jury consultant in this case versus the last case and how unusual that is for federal trials? For
Well,
criminal?
I don't think it's unusual for either side to consult with jury consultants. It's a fairly standard practice anymore in both state and federal courts. So,
Has it been done here before in federal criminal cases?
you know, I can't recall specifically where we've used a jury consultant, but if the question is whether or not it happens in federal court on both the civil and criminal side of the house, I think the answer is yes. Any other questions? Yes, sir.
On topic, but question for you. Attorney General Jeff Sessions, about an hour ago, asked for a revelation of 46 presidentially appointed prosecutors. That includes you. Have you been contacted by?
Actually, yeah, to answer your question, it doesn't include me. I'm appointed by the court here in the District of Oregon, and I'm not presidentially appointed. So whenever a presidentially appointed U.S. attorney steps down until there is another appointed by the president, then the Vacancy Reform Act, it's a federal statute, comes into play and designates periods of time and who has the authority to designate. And I I was appointed as the United States Attorney by the Chief Judge of the District of Oregon about a year ago. Any other questions?
Over the course of this trial, there was a lot of talk about the interpretation of the Constitution as it comes to the adverse possession concept. Are you in any way concerned that the last verdict might have an effect on future cases involving claims of adverse possession in the public land system?
Well, the reality is anyone facing trial can assert, or at least attempt to assert, a particular defense. And that's left up to the individual judges presiding over those proceedings on whether or not such a defense would be allowed. So if your question is, could it be asserted in other cases in the future? It certainly could be.
I would just add, in this case, Judge Brown specifically instructed that it wasn't, adverse possession wasn't some mechanism for acquiring federal land, so I hope that message gets out there.
Anyone else?
Do you have a sense of what you'll be recommending for their sentences and,
You know, that process involves getting a pre-sentence report, which happens in every criminal case in federal court in the District of Oregon. So it's our responsibility to wait and see what that information is, what it tells us about these defendants. I think at the end of the day, though, we want to convey, regardless of what the specific recommendation is, the severity of this conduct, the impact it had on the community, and the impact it had on the employees of the Fish and Wildlife Service and the BLM. So regardless of what the recommendation is, that'll be a message we'll be sending, as well as, you know, the long-term impact on the tribes and their interest in this property as well. So those are the kinds of things we'll be talking about at sentencing.
Sorry, just one clarification. You mentioned the High Desert Partnership. Is that the sage grouse thing, agreement that was reached?
No,
last year?
it's a group of citizens and county officials, ranchers, environmentalists who work together to address issues out in Harney County.
Okay, thank you, everyone.
Thanks.
okay, that's it.